Thank you all. Thank you so much for having me here today. And Barbara, thank you for that very gracious introduction. And it is indeed my pleasure to be with you this afternoon on this beautiful day in Washington, D.C. I am particularly thrilled to be here, not just to have the opportunity to chat with all of you and answer some questions, I hope, at the end of my presentation, but to see some old friends and to be, of course, with Barbara. Barbara, I will tell you, was one of the best, if not the best, expert witness that I've ever had the opportunity to hear as a judge. And her testimony was unique in the sense that it fell outside the sort of traditional ambit of science, and it was a compendium of information about the intelligent design movement, and it was challenged, and I had to write on that challenge and decide to admit that testimony. In addition to that, she is one tough cookie on the witness stand. I didn't have to give her a lot of air cover as the trial judge, because she held up well under some rather withering cross-examination, both on her expert qualifications and on the findings as well. Now, what was very interesting about it was that when I admitted her testimony, I said that in order, without getting overly technical here, but the fear that the defendants had was that Barbara would take something out of context, that she would cite something from a work or something that had been published by some of the leaders of the intelligent design movement and either misstate it or distort it or take it out of context. And the way that I resolved that when I wrote on that portion of the case was I said then I insisted that they have that material at the ready. The plaintiff's counsel have that at the ready, so that if there was a question, we could go quickly to that area and determine whether or not anything had been taken out of context or misstated. And not once during her testimony was there an objection in that regard, which sort of showed them for what they were, I think, ultimately. It's also good to be here to see a couple other friends. One who used to work with this organization, Richard Katsky, who distinguished himself as well in the, there's Richard over there, and Richard participated as counsel, co-counsel in the trial. Just a terrific attorney in every sense, and we've got to be friends and email pals over the years since the case. I know Richard has gone on to other endeavors, but was so valuable. And last but not least, your leader, Reverend Barry Lynn, is an old friend of mine and is a graduate of Dickinson College. Barry and I received some recognition at Dickinson a couple years ago and had lunch together at the President's house and proceeded to obnox everybody by getting deep into conversation and ignoring everybody else at our table. My wife reminds me of that very frequently. So let's talk about a couple of things today, and then I'll open this up for questions and find out what's on your mind, and try not to make any news and say anything that's ragingly provocative that's get this federal judge in trouble. But I'm here, and I recognize, because of the Kitzmiller case and the odyssey that I've been on over the last 5 years, and it is 5 years. I just concluded the trial, in fact, 5 years ago this month, and it has been a remarkable time for me, one that I wouldn't trade for the world. I hope that I got it right. I know you believe that I do. Some don't still, but it was a sort of seminal incident, not just in terms of, I think, the overarching issues, separation of church and state, so important to you, but also as it relates to teaching, as it relates to science and so forth. But there have been humorous aspects to this odyssey as well, and I've been all over. I think I've been to about 30 plus states, and I generally try to get out because I think it's good for federal judges to do that, and we don't always have a hook that gets us out the way I had with this case. So falls to us, I think, to explain a little bit about the judiciary and what we do. When I spoke earlier this year at Rutgers University, and it reminded me when I was in New Jersey, and for some reason I haven't been to New Jersey too much to do speaking, but I was in New Jersey, and then I thought about New Jersey natives, and I thought about Bruce Springsteen, and Bruce Springsteen, and you may or may not know this, but he is interested in these issues that are so important to you, and particularly interested in evolution. And he was giving a concert during the Dover trial. He was in the, some of you may know this, he was, I think, in the Meadowlands at the stadium, and he made the comment, he said, well, he was about to perform a song, I think it's called Man and Monkey, and appropriately enough, as he introduced it, he said, you know, he said, over in Pennsylvania, he said, our friends in Pennsylvania aren't so sure about evolution. He said, but you know, here in New Jersey, we're counting on it. So last year we celebrated the 150-year anniversary of the publication of Origin of the Species, and that caused me to get out a bit and talk about these things and to delve a little bit more deeply into some of the historical issues that were not really as relevant or important, although they were interesting to me during the trial. And I wondered, as I spoke around the country, if you'd told Charles Darwin in his time that 150 years after he published Origin of the Species, that this issue would be the issue of evolution and creationism, if it would be so prevalent. And I came to the conclusion that he probably would have guessed that. I don't think that he would necessarily be surprised at that. And it made me delve a little bit more deeply, and I know some of you have, and I don't mean to insult anybody's intelligence if you've been steeped in this, but I think it's well to look at where we've been, particularly over the 20th century and into the 21st century as it relates to this enduring debate, this quintessentially American debate that we've had over evolution and creationism, and it really implicates a lot of different things, that not just separation of church and state, not just legal issues over the Establishment Clause, but also science and teaching, as I said earlier. The granddaddy, you know, of cases was the Scopes case that was litigated in the mid-1920s in Dayton, Tennessee. And it's well to recall, I think, that in the Scopes case, the law involved was very brief and to the point. And it said teachers in public schools are forbidden to teach any theory that denies the story of the divine creation of man as taught in the Bible, and to teach that man has descended from a lower order of animals. And that was pretty much it. And you may also know that although the law was on the books, that not much was being done with it, and no one had been prosecuted, but there were many, and there was a growing sense who objected to the law. So they find young John Scopes, the teacher, and they grab Scopes, as history tells it, and they pull him into a drugstore in Dayton, and they say, "You're going to be the guinea pig here. We're going to have you violate this law, and we're going to see what happens, and we're going to have some fun with this and make a trial out of it." So he did, and he ended up in this maelstrom, this trial. But those of you who are scholars or who've been interested in this area and who've read some of the marvelous books like A Summer for the Gods know that This was a show trial in large measure. It was sort of to prove a point, but it wasn't, I would submit to you, as deadly serious in many ways as the federal trial that I presided over. It had some similarities, but it had distinct differences as well. So Scopes ends the case getting convicted. The jury's out only minutes. That wasn't the big story, although he was fined $100. The big story, as you know, was the cross-examination of the sort of hubris-filled William Jennings Bryan, who decided that he would take the stand. Some believe because he thought he was going to get a shot at Darrow, and of course Darrow arrested and didn't give Bryan a shot at him. So Bryan takes the stand and is eviscerated by Darrow, and of course the postscript of the story is that Bryan only lives for a short period of time after the case and dies, some think, of a broken heart, having lost that case in such a, or having lost the battle with Darrow, not having lost the case, because as I said, Scopes was convicted, but having not acquitted himself well in the face of Darrow's questioning. And of course that case generated tremendous interest in the United States in its time. But little known, and as you study this, is that it really didn't have an effect on the laws in those states, and there were many in the time, but not all, that prohibited the teaching of evolution. And so this clash didn't really move the ball much at all. And those of you who've discussed this with your parents or your grandparents or great-grandparents know that for many of them, they simply didn't learn about evolution in science class. It wasn't taught. Whether it was outlawed or not, it was too controversial of a subject, and it just wasn't anything. It was like a third rail that teachers didn't want to get into. And of course, although this was a Tennessee case, in nearby Arkansas, 3 years after the Scopes trial concluded, that state approved a referendum that prohibited both public schools and universities from teaching evolution. So Scopes didn't dissuade anybody, the Scopes case didn't dissuade anybody in Arkansas, obviously, and they decided they would pass a law. And that law, and this surprised me as I delved into the history of it, stayed on the books all through the 20s, the rest of the 20s, the 30s, the 40s, the 50s, and into the 60s. Now again, similar to Arkansas's, or similar to Tennessee's enactment, Arkansas was not really enforced. It was on the books. It certainly dissuaded people in the main from teaching evolution, but there wasn't much mention of the law until the mid-1960s, when a young science teacher, and you know this case, of course, Susan Everson, in somewhat similar circumstances, except now, as in my trial, something that I would submit was much more serious. Susan Everson becomes the prototypical plaintiff in a case where she is going to directly challenge this law, and she did, and had standing to do so. And she takes it through the district court and all the way through the intermediate appellate court and all the way to the Supreme Court. And the Supreme Court, in fact, strikes down the Arkansas law that prohibited the teaching of evolution in Everson versus Arkansas. And this was a seminal earthquake of a case in its time. And it sets one to wondering as you look at that case in the late 1960s as Everson resolved. And one wonders, why did it take 40 years? And what happened in that intervening period of time between Scopes in the mid-1920s and the Everson case that caused the Supreme Court to take a look at this and develop the law of the land, striking down the anti-evolution statute in that state. And I believe that it was the confluence of a number of things, but two things in the main. Now, for a large portion of that intervening period, as I said, evolution simply wasn't taught, so there was no case or controversy to get in front of the courts. But then we had the 1950s, the period of the 1950s that some of you in this room, of course, remember, and others have read about, and if you didn't experience it firsthand. And what did we have in the 1950s? We had Sputnik. We had great terror in the country as we began to believe that we were behind the Soviet Union in education, and particularly in science education. And you start to have this creeping sense that we better start teaching better science, including the teaching of evolution. And that's how, that's one of the reasons, I think, that we had interest on the part of the Susan Eversons of the world and those who gave her aid and support in that case that arose in the mid-1960s. But the other fact was this: we had a Supreme Court of the United States that I'm sure, and I think the lawyers in the room would likely agree with this, they wouldn't have, the Supreme Court of the 1920s, if a case had found its way to them, wouldn't have touched this with a 10-foot pole. But the Supreme Court in the 1960s was a different court, and the jurisprudence was different in the 1960s. And it's an interesting study as to how these things use the word evolve over time. And of course, in the 1940s, again, this is a little inside baseball, but there was a case that was a watershed case. It was Everson versus Board of Education in 1947, to be precise. And in that case, and the facts are not important for our purposes this afternoon, but in that case, the Supreme Court of the United States made a determination that really for the first time in a major case, they signaled that they were going to apply the Establishment Clause within the First Amendment to the Constitution in a way that delineated that separation between church and state. And they were going to apply it, perhaps more importantly, to the states and to state action. And this was a very significant development in the law in its time. And then there were a series of cases from 1947 to the point of the Everson case that repeatedly had the court applying the Establishment Clause to, again, what we call state action and prohibiting certain acts that the court found violated the Establishment Clause, and showed that the court recognized this separation between church and state. And using really the rationale that was grounded in Everson, the court, as I said, acted in the Everson case to strike down the Arkansas law. Now, this, of course, didn't end the controversy, and it continued. And what developed after that, as many of you know, was that it was back to the drawing board for the creationism folks, and they relabeled creationism as creation science, and they enacted in a number of states the so-called balanced treatment laws that mandated that if you decided that you were going to teach evolution, you had to give equal time to this thing called creation science. And that triggered a new round of cases. And although there was an interval of a couple decades before this bubbled up, and one of them was Edwards versus Aguilar in 1987, which struck down a balanced treatment law in Louisiana. It's well known to Barbara, obviously, and held that creation science was not science at all, but merely a reconstituted version of creationism. And this case set the stage, I would say, for the Kitzmiller case that I presided over in 2004 and 2005. And the Kitzmiller case really was the next wave, if you will, following the disfavor by the courts of creation science. And so comes to my courtroom intelligent design, tracing its origins back beyond, of course, 1987, but really becoming prominent after that point in time. Barbara, in her wonderful testimony during the intelligent design trial, during the Kitzmiller trial, was able to articulate this better than perhaps I can encapsulate, but among other things, as Barbara found, the basal text that was used in the, or to be used to teach intelligent design simply changed words reflecting the progression from creation science to intelligent design. Now, you know, again, that intelligent design accepts some tenets involved in evolution, but it rejects Darwin's view as to many things and as to some of the core points of evolution without getting excessively scientific. So it's not, I don't mean to say that it's evolution light, it's not that, but it's sort of a mixed bag of things. It is not accepted anywhere in the scientific community of any note. And my purpose today is not to dwell excessively on the Kitzmiller case. I think you've read about that, but you do know that the case arrived in my docket in December of 2004. It followed a rather raucous and bumpy year at the Dover Area School Board, where a faction of the board began to dominate. They were bullies. They were not particularly erudite by any means, but they were young Earth creationists. They decided that they were going to get their view of things into the main, and they were next about to pivot, some believe, into some other areas like history, like school prayer, areas that I think are I know are very important to you. But stop number one was the area of evolution, and they were bound to determine to do something. The administration tried to dissuade them, not loudly enough. I think that, frankly, the school superintendent and deputy superintendent were afraid for their jobs, so they did try to admonish them that they were going too far, but they blew right past them. The school solicitor attempted to dissuade them. They ended up sending him home and getting their own legal representation from the Thomas More Law Institute, who agreed to do the case for free. That didn't help matters, in my view, because when you don't have to pay for your lawyers in that situation, I think that can embolden someone and cause them to make bad choices. So after a number of school board meetings in 2004, they adopted a policy that was not exactly what they wanted. It had been watered down through the development stages, but nonetheless caused teachers to have to read a statement as they were about to teach evolutionary biology in the second semester of the 9th grade at Dover Area High School. And the statement was a fairly abbreviated statement. I know Richard would agree with this, and Barbara and others who were involved, but it was an important statement. And what it did, in sum and substance, was it juxtaposed evolution with this concept of intelligent design. It even in a short statement, tended to denigrate evolution and sort of point the arrow at intelligent design as the alternative to evolution, and directed students to this book that was on deposit in the library, having been contributed, which was an issue itself in the trial and where that book came from. The teachers of the Dover School District flatly refused to read this statement, and as I was saying to Barbara and to Barry at lunch, they were the real heroes besides the parents in this panoply, because they were very brave, for the science teachers in particular, and in some cases were working under great threat to their positions. So the teachers refused to read it, and the administrators had to read it. And somewhat hilariously, I thought during the trial it was posited that that this wasn't teaching, and that this shouldn't have been remarkable to students. Now, just think, you're a 9th grade student at Dover High School, and your teacher absents himself or herself, your science teacher, from the room and says, boys and girls, we're about to have a statement read by Deputy Superintendent Baxa. I'm about to leave. Now, the day before, they had to take a sheet home for their parents to read, in which the parents could sign the sheet and have them opt out of the classroom. Now, this is not supposed to be remarkable to a 9th grader. So they take it home to mom and dad, they show them the sheet, they decide whether they're going to opt out, they come back the next day, their teacher leaves, and in walks either the superintendent or the deputy superintendent, and with all the panache of somebody making a hostage tape, reads a statement about evolution and intelligent design. This is not remarkable to a precocious 9th grade student. I found that hard to buy, and I didn't buy that ultimately in my opinion. So, you know, it ends up in my courtroom, and as you know, and that's what brings me here today, I handed down a ruling in December that held that the school board's policy was unconstitutional, and I tried to do more than that because I thought it was appropriate, not because I was engaging in judicial activism or grandstanding, as some of the pundits held, but I wanted to be as comprehensive as possible, and I wanted to say what I saw during this great controversy, and particularly as it related to what intelligent design is and what it isn't. Because I had a strong sense that this was going to replicate someplace else, and I didn't want another judge to be uninformed and unenlightened about particularly the great expert testimony that I benefited from during the trial from Barbara and from so many others who appeared, and I might say the good lawyering as well. The lawyering was as good as you will find in any case anywhere, I think, not just in the United States, but around the world. So we are through then the Kitzmiller versus Dover case. It's old news, and we move on. But the controversy, as you well know, continues, and it has been unabated, and Barbara is in a much better position, and some of you I know are in a much better position to tell me about what's taken place post-Kitzmiller. I confess that I'm not an expert in that area, but I also confess that I suppose that I'll always be interested in these issues. You can't go through what I did and not have an interest in these things. And I'm fully cognizant that there are groups that are attempting to bring this to the fore again, and whether it's in the area of evolution or whether it's in another area that attends the Establishment Clause, there will be other cases and controversies. You, I'm sure, during this meeting or other meetings have talked about the state of the Supreme Court and where we might be headed from here. I know that you have some distinct viewpoints about that and some thoughts and desires in that regard. It is not appropriate for me to prognosticate, and I won't prognosticate about a particular case or controversy, but it is clear that if you examine the Supreme Court, and this is not a great state secret, you will find that there is a split, that you have justices who would be more in the accommodationist realm and might desire to blow up the tests that we use to decide cases of this nature. And again, for those of you who don't deal with these things directly, in Supreme Court jurisprudence, we had first the Lemon test, named after the case that it came from, and then later the endorsement test, something that was created by former Justice Sandra Day O'Connor. These are tests that measure, among other things, the purpose and the effect of the particular policy or enactment that we're measuring, that we're evaluating to see if it violates the Establishment Clause. I happen to think they're good, and I happen to think as a trial judge, we need something that creates a certain predictability, even though these cases can be somewhat counterintuitive and somewhat unpredictable. I think the tests in the main are good for trial judges to use. But there is a faction of the Supreme Court, quite clearly, I think, that believes these tests are not necessarily a good thing, and that they've led to results that are less than desirous. I might differ with those who think that we shouldn't have tests that create a certain amount of predictability. I do think, and again, this is not necessarily inside baseball or a secret, that there will come a time in the not too distant future that there'll be a case that will percolate through the judicial system and will get to the Supreme Court, and it will involve an attempt to pull these tests down and to open things up in a way that is different than we have right now. And I can only speak as a trial judge and say that if we have trial judges ad hocing these decisions, look out, because you're going to get a real disparate run of decisions across the United States, some of which I think will be problematical, not just from judges' standpoints, but also perhaps from the standpoint of the public as well. And I think if we have nothing else going for us in the judiciary, we have the principle of stare decisis, in which we build on cases that have come before, and that works pretty well in the law. Now, what I want to do is having talked about this history of the Kitzmiller cases, pivot for a moment and talk about judicial independence issues, because in the main, from my perspective, judicial independence is something that I've had to give a lot of thought to since the Dover case. And why do I say that? Well, as you may know, and as you can tell, I guess, from my biography, I was appointed to the bench by George W. Bush, and my background is Republican. And that created a set of expectations about me when I had this case arrive on my docket. I guess the expectations are that federal judges throw them for the home team when you get appointed, and that's not true, and that's not the way the federal judiciary operates. You could probably cite me to cases where you believe that to be the case, but I don't think generally that's the way that my colleagues operate. And I learned that through my Kitzmiller experience, if you will, that people really don't understand how judges do their work day to day, and in a larger sense, most of our fellow citizens don't understand Article 3, and they need a sort of a refresher course, or maybe they never quite learned the civics that involves the different branches of government. It's amazing when you go out and you look at some of the polling and the questions that get asked of our fellow citizens. And I saw one poll recently that said if you poll our fellow citizens, about 15% of them can name John Roberts as the Chief Justice, of the Supreme Court of the United States, but about 65% of them can name at least one judge on American Idol. And you know, I think that speaks volumes about the need for some good bedrock civics education. Many of our fellow citizens can't name all three branches of government. Some strain to give you even one. Many of our fellow citizens believe that somewhere in the United States Constitution it is stated that we are a Christian nation. They believe that if you can find that someplace in the text. So we have a lot of work to do in that regard. I think too that our fellow citizens misunderstand the judiciary, and they don't understand what our job is. And I like to think, and again, not a unique thought with me, but I endorse this thought, that we are a bulwark against the tyranny of the majority in the United States. What did these parents do who brought this lawsuit in Kitzmiller versus Dover? They pushed back. They exercised their legal rights against a very belligerent faction on a school board who they believed were violating their constitutional rights under the First Amendment of the Constitution. That's exactly the way the system was designed to work. But many of our fellow citizens, and again, let's take evolution. If you poll in the United States today, I think approximately half of our fellow citizens do not believe in evolution, or they think there's some deep and dark flaw in evolution. And I think it goes between 40 and 50%. Some of you would know the numbers, I'm sure, better than I do. But if you take that and then you overlay that against my case, many people thought, as we went through this case, and still think to this day, well, you know, if most Americans, or a significant portion of Americans, don't believe in evolution and don't necessarily want it taught and want to have creationism taught in public schools, why don't judges just get with the program? Why don't they do what the will of the people is in this case? And as you know, that writes out something that is grounded in the Constitution in Article 3. To review, you know, Articles 1, 2, and 3, 1 creating the Congress, 2 creating the executive branch, 3 creating the judiciary. Articles 1 and 2 are expressly designed to be majoritarian. The will of the people is reflected in the president and in the Congress. Popularly elected, responsive, sort of on the ground, doing the people's business, passing laws, coming up with initiatives in the country. But Article 3 created something that is so enduring, and I think was a stroke of genius by the framers, which was a branch of government different, and not just not majoritarian, but counter-majoritarian in the third branch. Now, there were great debates in the infancy of the country, and resolved in the main by Marbury versus Madison that created judicial review. But the Supreme Court has the ability to strike down laws that are passed by Congress and signed by the president, and it is something that is integral to the system of checks and balances that we have. But most people don't get that. And the other genius of the framers, or frankly, I wouldn't be standing before you as a federal judge still, is lifetime appointment. Because I'd be doing something else, I suspect, if we didn't have lifetime appointment for federal judges. So we're not majoritarian. We do push back. We are a bulwark against the tyranny of the majority, and I think that's exactly as the framers developed it. And of course, now to be a little bit more specific regarding the Establishment Clause. I concur with the jurisprudence that has developed over the last 60 years. I think that there has got to be the point where courts step in and do their work and do their duty as it attends some of the initiatives that have been beyond the pale and have attempted to conflate religion and government in a way that is simply unacceptable. And I hope that it is ever thus. It is, as some have stated, that wall of separation between church and state. It is a porous wall at times. It is an indistinct wall. I'm glad that I didn't sit on the Supreme Court of the United States and have to adjudicate the Ten Commandments cases, because I think it's hard to explain to a layperson how one plaque with the Ten Commandments can survive and another will not, based on rather tortured logic at times. And I don't say that to criticize Supreme Court justices. They have a very, very difficult job in that regard. So it can be an arduous task to decide some of these cases. At the end of the day, my decision, and I've said this many times since then, in the Kitzmiller case, was not a hard decision to make. That is, on the issue that was before me, was the enactment unconstitutional. The hard part came in the writing. The hard part came in deciding, as I said, how expansive I wanted to make the opinion and how much I wanted to write. Did I want to tackle, is intelligent design science or is it not science? Those were the tough decisions that I had to make, and as I said, that I hope that I got them right. And I want to close as I talk about the judiciary with something, and I know that some of you you'll bear with me because you've heard me speak before, and I may have told this story, but I think it's instructive for those of you who've not heard the story. And it emphasizes to me, we beat ourselves up as a country, and it emphasizes to me how good we still are, and how we're viewed by others, because I think we engage in a lot of sort of self-flagellation and self-critical analysis in the United States, and we need to pull the camera back every once in a while and see how we're viewed, perhaps